How to Protect Your Ideas with Intellectual Property Rights by Ankita Avadani. Our world is dependent on technology and the way information spreads. More than 3 billion people are now using the internet. The number of internet users has increased from 738 million from the year 2000 to almost 3.2 billion people in the year 2016. Now, what does this mean for us, a society that is completely internet dependent today? The cost of having abundant information exchanged at our fingertips may come at the price of losing a concept we valued so much until now, the concept of owning our ideas, aka not having to worry about others stealing what we've created. This is where the concept of intellectual property and rights comes into play. In order to understand how to protect our ideas, we have to understand what types of rights we have based on the rules of intellectual property. So how do we protect our originality and ideas when so many people have access to them online? We understand what intellectual property is and what our rights are. According to the definition of property rights from the Statute of Anne, that first addressed the concept of intellectual property in 1796 in Britain, IP is defined as a work or invention that is a result of creativity, such as a manuscript or design, to which one has rights for, and may apply for a patent, copyright, trademark, etc. too. Now, what does this mean? Now, this definition is a little old-fashioned and slightly complicated, so let's break down IP into simpler terms and modern examples that everyone can understand. In order to understand what IP does, let's take the example of the iPhone. In June of 2007, Steve Jobs released the first smartphone. Now, I'm going to ask a simple question. Now that this never-seen-before technology is available, and I choose to own an iPhone, does this mean I have the right to copy this technology and sell it to another company for profit? The answer is obviously no. And the reason why this example of a technology cannot be stolen is because of intellectual property rights. Intellectual property is otherwise known as the protection of creations for designated owners who created them themselves. Now, what exactly can I do with these rights? Well, there are really 4 breakdowns of what property rights are, but using the right examples, you'll definitely be able to understand how to utilize and choose the best option to protect your ideas today. An important concept of intellectual property is a patent. A patent is granted from the government to an inventor, making the inventor an owner for a limited amount of time. Now, there are 3 different types of patents you can obtain over the next course of years if going to a patent office. One of the types of patents, and the most common patent you can get, is a utility patent. A utility patent covers any sort of machine or algorithm that has a solution to a problem. An example of this type of patent would probably be the iPhone, a technology that should not be copied in today's society. The second most important type of patent you can receive is a design patent. A design patent protects how a sort of product is going to be made, aka the design process. An example of this patent would be how certain car parts should be made and used to produce a car, or the assembly line used in many factories today. Last but not least, the last type of patent and the least common type of patent you can receive is a plant patent. This sort of patent protects any breeding of a novel plant. An example of this type of patent would be medical marijuana in states where recreational use is allowed. The second big implementation of intellectual property is a copyright. A copyright is a right that gives the creator exclusive rights for a limited amount of time. It differs from a patent because it allows other people to use this idea as well without copying it at all. An example of a copyright would be a song with music lyrics. Just because I'm singing a song by Taylor Swift doesn't mean I'm stealing her idea. I'm really just using her creation for my benefit. Now, if I had taken her lyrics before she had published them, then that would be copyright infringement, an example of me stealing her ideas. The concept of a copyright now leads us to the concept of a trademark. A trademark is something similar to a copyright, but gives protected rights to a recognizable sign in order to distinguish product. An example of this would be the Nike logo and motto, "Just do it." The trademark is the last right of IP, and it basically allows you not to copy another product based on its look. It's basically like copying an outfit from a friend. Intellectual property creates economic growth and creativity. Next time you have a great idea, protect it with IP. Thanks for listening.
created using Powtoon.